County Attorney. For over 100 years, Arizona has fully protected human life from the moment of conception. In 1973, Roe v. Wade temporarily stopped that protection. That mistake put Arizona in a bind. Had the legislature done nothing, unborn life would have been fully unprotected, all the way up to birth, for 50 years. That was unconscionable. So the legislature reenacted Section 3603 to fully protect unborn life, except to save the mother. And it passed supplemental protections, carefully saying these laws did not repeal Section 133603.
But Mr. Warner, that didn't actually occur right away. Nothing happened after 1973, absent statute, I think, that said that physicians don't have to perform abortions. But then it just pretty much meandered along into the late 90s with the ban of partial abortion, and then a ban in 2000 with post-viability, with none of the language that you're citing that kind of came into existence around 2010 with the first 20-week limitation. So is that accurate, that up until 2010, there was no language and no indication in any of these laws that the legislature intended that 3603 be applicable?
I don't believe so, Your Honor, because in the 1970s, in fact in 1977, the legislature reenacted Section 13-3603, and it carefully enacted supplemental protections all along the way, saying that these supplemental protections created no right to an abortion, that they legalized no currently unlawful abortion, and then, of course, most recently, just last year, the legislature reaffirmed Section 13-3603, saying that SB 1164 does not repeal that law.
Are you asking the court, however, to effectively say that with the decision in Hobbs, that effectively all of the Title 36 provisions restricting abortion, regulating abortion, causing the Department of Health Services to enact rules and such are now effectively nullified?
Absolutely not, Your Honor. In fact, in our view, we believe all those regulations are fully applicable, and I'm happy to walk through with the court how all these laws fit together post-Roe.
Why don't you start with 362322?
Yes, Your Honor. Starting with Section 362322, that law is otherwise known as the 15 weeks law, and it requires that after 15 weeks that determination be immediately necessary to either preserve the mother's life or to prevent significant and irreversible bodily impairment. So if we pair that with the pre-Roe law, which is Section 13-3603, here's the straightforward way that all these laws fit together. Up to 15 weeks, the termination must be life-saving. After 15 weeks, the termination must be immediately necessary to either save the woman's life or to prevent significant and irreversible bodily impairment. There's an immediacy requirement that kicks in at 15 weeks, and for good reason. The state has a growing interest in protecting unborn children. So at 15 weeks, they apply this additional requirement, which requires that the termination not only be life-saving, but immediately necessary to preserve the mom's life and to prevent significant and irreversible bodily impairment.
So the 15-week ban is in effect?
It's fully applicable alongside the pre-Roe law, Your Honor, because of that immediacy requirement. There's a timing requirement in the 15 weeks law that's simply not present in the pre-Roe law. To satisfy the pre-Roe law, the termination need only be life-saving. But not all life-saving terminations are emergencies.
And you say it must be life-saving because of the language of 133603?
Yes, Your Honor. So if you're reading these laws together, Section 13-3603 requires that the termination be life-saving. But not all life-saving terminations are immediately required. For example, there are certain cancer treatments that could wait a week or a month or even a couple of months, or certain cardiomyopathies that might not require an immediate termination. So after 15 weeks, the state adds an additional protection for unborn life. It says that the termination must not only be life-saving, to agree with Section 13-3603, but it must be immediately necessary to either preserve the mother's life or to prevent significant and irreversible bodily impairment.
I'm still a bit confused about how 2322 works. If you represented a physician, the physician came to you and asked you, may I legally, in the state of Arizona, perform an abortion if I've determined that the gestational stage for the fetus is less than 15 weeks, would your answer be yes or no?
If the termination is life-saving, there is no problem under Arizona law if it's before 15 weeks.
It has to be life-saving, though, because of 3603.
Correct, Your Honor. The legislature created Section 13-3603 to ensure that any termination before 15 weeks is life-saving. The 15 weeks law kicks in at 15 weeks to add the additional requirement that determination be immediately necessary to protect the mother's
So if I
life.
understand you correctly, we're not arguing about whether the legislature modified 3603 when it passed 362322. We're simply arguing what that modification was.
Exactly. It's like any other regulation in Title 36, Your Honor. It adds an additional immediacy requirement that the original law never had. And it makes good sense because as we've learned over the past 50 years, the science has shown that the viability line for unborn children keeps going down and down. And once that 15 weeks law kicks in, there's an additional protection for unborn life, ensuring that the termination must be immediately necessary to either protect the mother's life or to prevent significant and irreversible bodily impairment. And this is to say nothing of the construction directives, which should control this entire argument.
Well, let's look at the intent directive instead. I would, if indeed the intent was to do as you were saying, I would expect to find that in the intent section. Instead, what I find is the following language. The legislature intends through this act to restrict the practice of non-therapeutic or elective abortion to the period up to 15 weeks of gestation. What I hear you saying is there is no such thing as elective abortion. So how do we follow the intent that the legislature actually told us to follow?
Yes, Justice Bollock. I believe in that same provision that you just cited. It talks about what this act, what SB 1164 was doing. And of course, it does not pretend to regulate any termination before 15 weeks. That's what Section 13-3603 does. But that purpose language accurately reflects that the legislature was enacting this law in the context of Roe. Roe allowed certain abortions, and the legislature was basically setting the limit for permissible abortions here in Arizona. So that purpose statement really does nothing more than acknowledge what the effect of Roe was and say, look, we're coming in and we're issuing the ceiling to this law.
Doesn't it also suggest that the language in 362322B, when read in light of the legislative intent in Section 3B of the initiative, is referring to non-therapeutic or elective abortions and not to abortions that are necessary to preserve the mother's health?
I don't believe so, Your Honor. That provision, it only purports to regulate terminations after 15 weeks based on its language. It does not regulate terminations before 15 weeks. In fact, the statute is silent as to terminations before 15 weeks. The absence of regulation in Section 36-2322 does not preclude the legislature from further regulating abortion in other statutes, including Section 13-3603.
What about 362301.01, which is the one that was enacted since 2000 and is still on the books, it's never been repealed, that says that a physician shall not perform an abortion post-viability, but it's okay pre-viability.
Yes, Your Honor.
What's the status of that?
Of course, I believe it can be fully applied alongside Section 13-3603. So once the unborn child reaches the age of viability, the provision you mentioned, the viability law, kicks in to ensure that whatever procedure that the physician provides, it's going to protect the unborn child. There is no conflict between the viability law and Section 13-3603. That provision does not allow any termination that Section 13-3603 forbids. And I want to address the construction directives because I think that they are critical to understanding how these laws fit together. First, SB 1164 says Title 36 does not repeal Section 13-3603. Repeals can be full or partial, and they occur even when the law's scope is limited. Under the interpretive direction canon, Title 36 cannot limit Section 13-3603, and other canons cannot reverse this priority because the legislature has is expressly given this priority in its construction section. Second, Title 36 creates no right to an abortion. The legislature did not say fundamental right, constitutional right, or any other kind of right. It's just talking about a plain old right.
But do you need to give the woman a right to an abortion in order for the legislature to decide we're going to restrict who we're going to prosecute for performing abortions?
Well, Your Honor, I would say under respondent's view, every outcome ensures that either the woman or the physician has a right to perform an abortion. And it creates a right three different ways. First, it creates a statutory right to an abortion because under respondent's view, Title 36 expressly permits terminations before 15 weeks by statute. Second, it creates a negative right to an abortion. It ensures that the government cannot apply Section 13-3603 to regulate physicians. And it creates a conditional right to an abortion, ensuring that if physicians complete the requirements of Title 36, they can complete a termination before 15 weeks. The legislature intended none of this by design by saying that Title 36 creates no right to an abortion. Third, Title 36 legalizes no currently unlawful abortion. And to be fair, I think this provision could be read two ways. It could be read to suggest that this law legalizes no currently unlawful abortion at the time that the act was created. That's one view. I think the better read, though, is that this provision is directing courts how to construe the law at the time that they are asked to interpret it. They're saying this law legalizes no currently unlawful abortion. And in context, it comes underneath the construction section in the statute. So the legislature is telling courts this is how you should construe this.
At the time this was passed, abortion up through the second trimester was effectively legal because of the decision in Rowan and Casey. Is that what it's referring to? So really there was certainly a broad permission for abortion in the state of Arizona at the time this was passed. Is that what the currently unlawful means?
I don't think so, Your Honor. And I think in context...
It doesn't mean unlawful except for the United States Supreme Court.
I think what this provision is getting at is when it says that Title 36 legalizes no currently unlawful abortion, it's talking about currently at the time when the law is being interpreted. We often talk about current or currently in this situation.
So it's current in light of what happens in the future.
Well, for example, Your Honor, if I said...
That seems like an unreasonable reading to me. But.
Well, let me try to persuade you, Your Honor. So we often use current or currently even when referring to future conduct. For example, if I say use the current password next month, I'm not saying use the password that's going to work today. I'm saying use the one that's going to be in place next month. Or another way of saying it is use the password that's currently applicable next month. And I think in context, this really gives this provision meaning because over the past 50 years, the legislature is creating increasingly pro-life laws. And if they're saying that this law legalizes no currently unlawful abortion, it's not really going to have much meaning if the laws are getting stricter and stricter in this context.
Well, couldn't they have simply said, been a little clearer for all of us, and said that if Roe versus Wade is overruled, that in that case, this 133603 will take place, or in the next legislative session after the Dobbs decision, simply do just that.
I'm sorry,
go ahead.
Your Honor, we can certainly debate the art of these provisions, but I do believe the grammar is sound. What the legislature did give us is that it said, look, this 15 weeks law, it doesn't repeal Section 13-3603. It creates no right to an abortion, and it legalizes no currently unlawful abortion. Could the legislature have...
So what was the point of it? Why pass this? Well, it didn't do anything.
Well, two responses, Your Honor. Of course, at the time that the legislature passed the 15 weeks law, the Roe v. Wade decision was in full effect. So they were legislating against the...
In fact, they hoped what would happen was that Dobbs would come down and find the Mississippi law to be constitutional.
They were certainly legislating in the context of what was happening in Mississippi, but they didn't mirror everything that Mississippi did. Arizona is certainly free to use its own words to accomplish its own objectives, which is what it did here. And like I mentioned earlier, the 15 weeks law still has tremendous meaning even after the injunction below is lifted. That's because it adds an additional requirement onto Section 13-3603 and requiring that the termination not only be life-saving, but immediately necessary.
In fact, if Dobbs had come down the way they anticipated, what they intended was this statute would make abortion possible up to 15 weeks in the state of Arizona, elective abortion. That's why they passed this, isn't it?
Well, Your Honor, we can debate the legislative intent here, but I believe the legislative text is clear. What the legislature did is that it created an additional requirement on top of Section 13-3603. Up to 15 weeks, the termination must be life-saving based on the pre-Roe law. After 15 weeks, the termination must also be immediately necessary to protect the mother's life or to prevent significant and irreversible.
And the point I'm trying to make with you is I think that if in fact Dobbs had done what the legislature intended, that would not be the argument you'd be making. You'd be making this as constitutional because it allows an elective right to abortion up until 15 weeks. But what I'm suggesting to you is what it looks to me like is their intent was to create a statute that would accomplish that. And they just got more than they asked for.
Well, I think they were legislating understanding that multiple outcomes were in place. Certainly if Roe stayed the legislature's hand and they could not fully imply all the laws that they passed over the past 50 years or even 100 years, that's one thing. But what the legislature did was it ensured that if the Dobbs decision was a win, whether the court simply upheld the 15 weeks law or whether it went the whole way and reversed Roe, that unborn life would be protected to the greatest extent possible here in the state of Arizona.
Well, and at the time that 2322 was passed, you previously had the 20-week limit. Now you have the 15-week limit. The 20-week limit had been declared unconstitutional by the Ninth Circuit under the Isaacson case. So assumingly that the 15-week ban or limit was already unconstitutional as soon as it was passed, accepting Dobbs. Is that accurate?
I don't believe there was any injunction forbidding the enforcement of the 15 weeks law. Certainly if it were challenged, the Isaacson
Right. I mean,
decision could be
there was
persuasive.
no order in place, but if the 20-week wasn't going to fly with the Ninth Circuit, neither was the 15-week, obviously.
And I think this certainly illustrates that the legislature was doing the best it could to protect life at every stage along the way. If Roe fell, then certainly the old pre-Roe law, the Section 13-3603, could be revived simply with a lifting of the injunction, which is obviously what we're here today asking.
And the reason I
court to do.
raised it was, doesn't that feed into what the Chief was just saying, that what the part of the context that was occurring here was hopefully the Dobbs decision the legislature had hoped would overturn essentially, effectively, the Isaacson decision and allow a 15-week limit in place.
Yeah, I don't think the legislature precluded the possibility of the U.S. Supreme Court also overturning Roe. That's why SB 1164 said, look, we're not repealing our pre-Roe law, Section 13-3603. So it wasn't as if the outcome was uncontemplated just by the very text in the statute. And indeed, after Roe fell, all these laws fit together perfectly. Up to 15 weeks, the termination must be life-saving. After 15 weeks, the termination must be both life-saving and immediately necessary.
So taking the Chief's question in a different direction, let's say that Roe had not been overturned, but the 15-week limit was sustained there. Then obviously our law would have been in operation, and if a physician complied with that law, the physician could not be prosecuted, right?
Correct.
So I don't understand then how that law is not in conflict with the territorial ban if something that could not be prosecuted now can be prosecuted.
Well, Your Honor, I would say that these laws can be read together. This court should certainly construe all the text together to the extent it can. I don't believe there's a conflict, and I'll come back to that if this court disagrees with me on that. But I believe the fair reading of the 15 weeks law is that it creates an additional requirement on top of Section 13-3603. It's like adding a physician-only surgeries requirement or a physician-only drugs requirement. You can further regulate conduct in addition to Section 13-3603 without there being a conflict, and that's what the 15 weeks law does. After 15 weeks, the termination must not only be life-saving based on the pre-Roe law, it must be immediately necessary, so there's an urgency
But to be
requirement.
clear, in response to Justice Bullock's question, if it had occurred as his hypothetical suggests, the physician could not have been prosecuted because otherwise it wouldn't have been constitutional. The physician couldn't have been prosecuted for performing an elective abortion up to 15 weeks, correct?
Yes, but that's only because of the pre-Roe law being enjoined.
But it's also because of the language of the statute.
I don't believe so, Your Honor. If we look at the language of the statute, it only purports to regulate terminations after 15 weeks. It in no way purports to regulate terminations before 15 weeks. And I think that was on purpose because the legislature said that nothing in that law was meant to repeal Section 13-3603.
If the Supreme Court in Hobbs had upheld a federal constitutional right to an abortion up until 15 weeks, would there be any need or purpose for the legislature to statutorily recognize that right?
There would be no need for the legislature to recognize it because the U.S. Supreme Court has said it's there. But certainly they are legislating against the backdrop of the law as they know it. This court obviously presumes that legislatures know applicable laws at the time that it is enacting its statutes. Yes, Your Honor. I also want to quickly talk about how the additional Title 36 regulations fit in with and apply alongside the Section 13-3603. Obviously, the gestational age requirement is still applicable because physicians need to know when the immediacy requirement of the 15 weeks law kicks in. That's why they need to determine whether the termination is at or before 15 weeks. And then respondents talk about a host of informed consent laws and notices and ultrasound rules. All of those apply in cases that are not emergencies. Of course, not every life-saving termination is an emergency. So for those life-saving terminations, those laws would fully apply without incident. And the reporting requirements have been discussed by the parties. Of course, life-saving terminations are fully reportable events. Nothing will prevent physicians or hospitals from complying with their reporting duties if the injunction below is lifted. Then we have the reason law, which is Section 13-3603.02. It also applies unless there is an emergency. Not every life-saving termination is emergency, so that law retains its full vitality.
Mr. Warner, so if an abortion is performed, say at week 17, and a physician performs an abortion, that would be a violation of 13-3603, and there's no life-saving involved. It's just an elective abortion after that time. Would that be a violation of both the criminal statute and 36-2322?
So the termination is at 17 weeks, as I understand it. It's not life-saving, so it would not. It would violate the pre-Roe law, Section 13-3603, and to satisfy the 15 weeks law, the termination would need to be immediately necessary to protect the mother's life or prevent significant and irreversible bodily impairment.
So under that scenario, it would violate both statutes.
If it was not immediately necessary, as I understand your hypothetical, Your Honor, that's correct.
And of course, I'm getting to the next question, which is, but there are different criminal penalties under each of those provisions. So it's a 2 to 5 year imprisonment term under what we've been calling the territorial law, and then it's a class 5 felony, or class 5 felony, which is a different punishment. So what do we do with that conflict?
Well, as I understand it, the parties do not dispute that these laws regulate separate offenses. Of course, other law would kick in and ensure that that the prosecutors would have discretion to choose, just like they would have discretion to choose under any other law, which that they were going to prosecute under, depending on if the elements were satisfied.
Does that give a due process problem for notifying physicians of the potential consequence of violating the law if you're depending on, 15 different county attorneys' discretion under which law that they will prosecute?
Well, county attorneys, the legislature has said that they shall prosecute offenses if they have reasonable information. So these attorneys should apply the law. They should faithfully try to apply the law. But to the extent that we have individual county attorneys declining to prosecute the law, the fact of uncertain enforcement doesn't make the law unenforceable. There's nothing unclear about the law itself. Another way of saying it is that there's nothing uncertain about the law, and if there's uncertain enforcement, that means that county attorneys should apply the law as given, consistent with their statutory duties. I see my time is about up for opening argument. Unless there are other questions at this time, I'd like to reserve the balance of my time for rebuttal.
Very well. Mr. Gale?
Good morning, Your Honors. May it please the Court. Andy Gaona with Coppersmith Brockelman here on behalf of Planned Parenthood, Arizona. As the Attorney General's motion regarding oral argument previewed, our side has decided to try to divide our time as best we can, understanding that that may not happen as we wanted to. But
Do you keep track of the time?
I will endeavor to take up about 13 minutes, the Solicitor General 12, and the Pima County Attorney the balance, which would be 5 minutes. I want to take a step back for a moment to put this case into some context. 50 years ago, when the Court of Appeals declared the territorial ban unconstitutional as to all, that was the only regulation of abortion on the books in Arizona. Since then, the legislature has enacted dozens of statutes that prescribe the who, the how, and as relevant here, the when of that important healthcare procedure. But never once in that half century of legislating did the legislature ever signal any intent that most, if not all, of those subsequent enactments would become mere empty shells if Roe versus Wade were ever to fall. And the legislature could very easily have done so. As the parties have briefed extensively.
So address Mr. Rao's point in response to Justice Lopez's question. I mean, what was the purpose of this if it wasn't simply to put a cap on when an elective abortion could occur in the event the U.S. Supreme Court made that constitutional?
I agree that the point was to alter the permissions for when an abortion could occur if the Supreme Court had moderated itself, for example, and not overturned Roe versus Wade, but had upheld Mississippi's law. And so I do agree that that was the point, and I think that gets to a lot of the questions that we discussed here, that as we went from what was a viability law to the 20-week law that was ultimately enjoined to the 15-week law, what you saw was the legislature changing the conduct that was permitted and how abortions could be performed, who they could be performed by, and when they could be performed.
Under the auspices of Roe.
That's correct, Your Honor.
So where in Title 36 is there a freestanding right to an abortion?
Your Honor, we have never maintained that there's a freestanding right to abortion in Title 36, nor does
That genesis of that right came from Roe.
that's
Roe Casey.
we fully concede that the legislature was at this time was legislating against the backdrop of Roe. But the interveners have said, well, because in the construction provision, the legislature disclaimed the creation of any right and cite a definition of Black's Law definition of the word right, QED, they win. But that's not how criminal laws work. Criminal laws permit, authorize, allow, whatever you want to say, that which they do not criminalize. And here in the specific context of abortion and in the specific context of the 15-week law, the Arizona legislature said physicians can perform abortions up to 15 weeks LMP, and they cannot be prosecuted for that. And I heard Mr. Warner agree that had the law gone fully into effect, that was the law. That's the law as we sit here right now under the Court of Appeals decision.
Does the legislature need to declare a right for a woman to have an abortion in order to decide to limit the circumstances in which a physician may be prosecuted for performing an abortion?
Absolutely not, Your Honor. The legislature need only regulate conduct through the criminal code. It does it all the time. If a statute says that the speed limit is 45, I don't have a freestanding right to drive at 35 miles per hour. I can't be prosecuted as a function of due process, of course, but I don't have a right to do that. And I think this illustrates itself well if you consider a world, again, in which the U.S. Supreme Court had not overturned Roe versus Wade. We still have Roe in the background, but we have the 15-week law. We wouldn't say that physicians have a freestanding statutory right to perform abortions under that framework. We wouldn't say they have a statutory right. We would say that it is legal for an abortion to be performed in that context. The same way that it is legal for me to drive 35 if the speed limit is 45, but I don't have a freestanding right to do it, nor does the legislature have to create one. So I think the focus on whether or not a right is created is a complete red herring.
Conceding that point, there's other language that appears to be more problematic. The legislature does not intend this act to make unlawful an abortion that is currently unlawful, or to make lawful an abortion that is currently unlawful, and it also specifically references the territorial law and says that it's not repealed by implication or otherwise. What does that all mean?
So I think there's a couple questions in there, Your Honor, so let me try to address them in order. So with respect to currently unlawful, I disagree with Mr. Warner about the time in which we have to look at currently. Currently means the world in which the legislature was enacting that statute and when the bill was enrolled.
What about ARS 1, Section 1-214 that provides that words in the present tense include the future as well as the present?
I think there's a couple responses to that, Your Honor. The first is that currently is not a verb, so it doesn't really have a tense in the traditional sense. So I'm not sure we can apply that particular statutory construction piece to that. But the other thing is there's a perfectly valid explanation for that exists completely outside of this, which is that there are a host of other statutes that continue to limit the abortions that physicians can perform in Arizona. Mr. Warner mentioned one of them, and perhaps the biggest one that's been in the discourse in the reproductive rights space, which is what has been called the reason ban. There's a separate statute within Title 36 that bars physicians from performing elective abortions if they know that it is for certain prohibited reasons. So I think what the legislature was doing there was signaling that when we are enacting this revised permission for physicians, we are not intending to repeal the prohibitions we placed earlier on physicians, which would include the reason ban, for example. So I think that's how you can fairly easily deal with the currently language. As to the not wanting to, or the second part of the construction section about not wanting to repeal impliedly or otherwise 133603. But I think it's important that the statute doesn't just say that. It says 133603 or any other statute regulating abortion. And so on that point, I would say two things. The first is that, to take the second part, to adopt the intervener's view and construction of the statute would in fact actually impliedly repeal scores of statutes because they would become useless and unenforceable. I think one of the amici on their side said that some laws, to be sure, some laws may get dusty, which I appreciate as a writer, but it's a very clever way to say that they will be unenforceable and in fact impliedly repealed. The second thing I would say is that by harmonizing the statutes as the Court of Appeals did, the statutes being the territorial ban and the 15-week law, nothing has been repealed, either fully or partially. ARS 133603 remains on the books today. It's never come off the books. And we concede, Planned Parenthood conceded below, that the injunction should be lifted, in part, such that 133603 could be enforced against non-physicians. We agree with that. That is, a statute that can be enforced is definitionally not repealed.
Would it be enforceable against physicians past 15 weeks as long as it was an elective abortion?
No, Your Honor. We believe that in enacting the 15-week law, that is now the criminal prohibition for physicians who commit elective abortions outside of the scope of that law. What I would say further on this repeal point, because this, I think, is the two primary arguments that interveners now rest on, and which have been...
Let me make sure I understand before you move on. So you say a physician that performed an elective abortion after 15 weeks couldn't be prosecuted under the territorial statute, but could be prosecuted under the new statute 2322.
Correct, Your Honor.
Okay, I understand. Thank you.
And on this point of implied repeal, I would say one other thing, which is that this court has drawn a distinction in its case law. The most recent example I could find was in the Cave Creek versus Ducey case, which I think was 2013, about what you do when there are statutes that appear to conflict, that there is a difference between implied repeal and implied amendments. And so this is where I think looking at the construction provision of SB 1164 is important. Because what it says is that the legislature is not intending to repeal impliedly or otherwise 133603 or any other statute. It does not, as Mr. Warner got up here and just told you, it does not say anything about limiting. It does not say anything about impliedly amending. And I think that is if we are looking to what actually happened here, when you have a series of statutes that are not self-referential, that don't necessarily say we're repealing an old permission, we're just putting something else on top of it. What you have in effect is an implied repeal, and that's okay. And in fact, this court, in citing an example of an implied repeal that was perfectly okay, cited a case called Reeser, which is, and I will give you the quote here because I don't believe any party has cited it before, but it's 109 Arizona 473, excuse me. And there you had an old statute, there was a tax statute, the most exciting kind, of course. You had an old tax statute and a new tax statute. There were differences between them. And this court ultimately said, we find that the newer enactment impliedly impliedly amended the older enactment. And we read those things in harmony. And the court's language there is that those two statutes, quote, should be read and considered together, and both should be given effect where possible. That's exactly what the Court of Appeals did. That's exactly what we are asking this court to do with respect to the territorial ban.
How do you respond, though, to Mr. Warner's point that he can read them together as well? He simply says that past 15 weeks, there's the additional added requirement that you show that that is immediately necessary to save the woman's life, and so that can work in harmony with 133603.
But I think the problem, Your Honor, is that construction would, in fact, impliedly repeal an entire subsection of 2322. And the legislature, when enacting this, was surely it wasn't intending to do nothing if Roe versus Wade were to fall, or even if Dobbs had come out the way everybody thought it might, which was to uphold the Mississippi law. And I think in this context, if we are looking not to operative law, but to session law for legislative intent, if the legislature's intent was truly that the 133603 should be resurrected in full and enforceable as to all if Roe versus Wade were to ever be overturned by the U.S. Supreme Court, I don't think it's too much to ask the legislature to state that clearly. And they clearly didn't do that. We've talked a lot about what the legislature has said in this context, but let's not forget that the governor that signed this bill into law, no fan of abortion rights, I think we could all agree on that, both pre-Dobbs and post-Dobbs stated his belief and his understanding that the 15-week law would be the law of the land regardless of what happened with Roe versus Wade. We have a problem. There was a problem here. The legislature could have fixed this up front, as the Vice Chief Justice pointed out in one of her questions in the legislative session that came after. They could have tried to clarify it there. They didn't. The fact of the matter is the legislature did not enact a full version of Mississippi's law, which everybody agrees our 15-week law was based on, because they didn't have the votes. They left out two key sentences of the construction provision from Mississippi, and had they done that, we probably wouldn't be standing here today before you. But in effect, what the interveners are asking you to do, and what the legislature, the legislative leaders, I should say, who filed an amicus brief are asking you to do, is to impose through an opinion that which they could not secure the votes in the legislature for. This is ultimately a policy question. Should we have a total abortion ban in Arizona that is enforceable against everyone, including doctors? Well, my client has a position on that, but that is not a decision that this court should be making. And what has happened here is that decision has been thrust upon you. But, what we can rest on is a well-reasoned Court of Appeals opinion that resolved this case the correct way. And we can also say that we have the backdrop of settled canons of statutory construction that resolve this case.
And just to be clear, there's no doubt that in this case, whether even the 15-week ban is constitutional under Arizona's constitution, explicit privacy rights, that's not an issue in this case.
Correct.
Purely statutory construction.
Correct, Your Honor. And I see that my time has since expired. I'm going to try to keep this as best as I could, but I'd just like to leave the court with one thought before I sit down. And that is that abortion is health care. And I'm not sure that anyone has ever said those words in this courtroom before, so they bear repeating. Abortion is health care. And what that means is that this court's decision will have a profound impact on the ability of pregnant Arizonans to access that health care from PPAZ and other providers. Thankfully, reaching the correct decision is not difficult. As we've argued, a straightforward application of this court's precedent dictates the outcome squarely in PPAZ's favor. But of course, the only reason we're here today is because in Dobbs, the U.S. Supreme Court cast aside precedent when doing so was not necessary to decide the case before it. We urge the court not to make the same mistake. Instead, this court should affirm the opinion below and affirm that Arizonans have access to abortion up through 15 weeks LNP. Thank you, Your Honors.
Mr. Bender.
I do think that we would have expected it, that if the legislature had intended to ban abortion in the state of Arizona, they would have spoken clearly. They would not have used ambiguous construction language, which is what ultimately interveners rely upon.
But what about when the fact that when the legislature, when it drafted 362322, it did not amend or repeal 133603, it just left it alone?
It explicitly said it was not repealing, but it didn't forsake whether it was amending it. And part of what I think is important, Justice King, is that even before you got to the 15-week law, we had this whole plethora of statutes in Title 36 that create a direct conflict, as does the 15-week law, with the territorial era law. And those statutes expressly permit abortions in medical emergencies and only make sense if abortions are permitted up to a period of time. So the informed consent statutes, for example, most of their provisions don't apply in a medical emergency. So under interveners' position, they would be totally useless, all those statutes. Same with the judicial bypass statute.
Well, following up Justice King's question, I think that Mr. Gaona indicated that in harmonizing the statutes, the newer statute would become the principal, if not almost exclusive way of enforcing limits on abortions. You said something in your brief, your response to amici, that I think is very important, but I'm not sure I have any idea what it means. You said maintaining Section 133603 preserves a catch-all ban on abortions that are not permitted by Title 36 and also preserves a stricter sentencing range for prosecutors to pursue. What did you mean by that?
So if you look at the court, I think it's consistent with what the Court of Appeals said in their disposition, that 133603 can't be enforced against licensed physicians who perform abortions that comply with Title 36. By the converse, it can be enforced against licensed physicians, against people who perform abortions that don't comply with Title 36. And the penalties in 133603 are 2 to 5 years, which are substantially more than a lot of the criminal penalties that exist in the rest of Title 36. And so there is real teeth to the fact that, per Justice King's question, 133603 is not repealed. It's on the statute books. It has force and effect, but it has to be read in light of all of these later statutes that the legislature.
Is your answer to Justice Bullock's question, is that in conflict with Mr. Gaona's answer to an earlier question that I asked about the same thing? And he said that for physicians, the only way to prosecute is under 362322 and the penalties there. And from what I thought I heard you say that a physician could be prosecuted under 133603 if they perform an abortion post 15 weeks that doesn't comply with the 36 restriction.
It's a very good question that you're both getting at. I think there are two very plausible ways to harmonize these statutes. One is that what remains of 133603 is it applies to non-physicians, given the extensive regulations in Title 36, and that's the one Mr. Gaona was advancing. The other is that 133603 also applies to physicians when they are acting in a manner that doesn't comply with Title 36. I think both of those are very plausible ways that the court could harmonize the statute. The Court of Appeals honestly was not always clear as to which of those two it was adopting. If you look at some of their earlier part of the opinion in the disposition, it's not really clear. I think the court could do either of those.
So that isn't contrary to the Planned Parenthood's position?
The second interpretation is, I know Mr. Gaona disagrees with. Yes, I think they're both plausible, and they both give effect both to the territorial era ban and to the express permissions contained in the text of both the 15-week law and other provisions in Title 36. And the text is very important. It says that a physician can't do an abortion unless he does certain things, or except if certain things. And except and unless are words that means if you fulfill their conditions, you're allowed to do the thing that you're only allowed to do if those conditions obtain. And we see that in the Village case from the U.S. Supreme Court, which was also construing an unless clause in an abortion statute. We see that in the way our legislature has enacted other statutes, which we cited in our briefs. We see that just in the way people ordinarily use those words. They're words of authorization or permission. They're not words of rights, to Justice Bean's question, but they're words of authorization and permission. And that creates an express conflict with the territorial era law that this court has to deal with through ordinary tools of harmonization, not through repeal, but ordinary tools of harmonization. And what's critical is if the legislature wanted to do what the interveners said, then they would have just included one sentence from the Mississippi law, which our 15-week law was based upon. And that sentence said, an abortion that complies with this section but violates any other state law is unlawful. They didn't include that, even though they borrowed the Mississippi law. And there are plenty of cases from this court, Welch, Boucher, making clear that when the legislature has an opportunity to adopt certain language or uses a model statute and omits language from the model statute, that omission is an important statutory choice. In addition to that, the legislature never enacted any other provision ever stating that the older, more general law, 133603, would prevail over the newer, more specific laws. And really what the interveners want is to have you turn the normal rules of statutory construction on their head, but without any enactment from the legislature telling you to do so, just based on their supposition that that's what the legislature intended. But if the legislature wanted its intent to become law, they needed to enact their intention into law, and they didn't do that. If the legislature had intended to ban abortion in this state, we would have expected it to speak clearly. We would have expected it not to use language that confused other members of the legislature, the governor who signed the bill, and who gave the hard call to this court.
Is there any authority, by the way, that suggests that the governor's expression of intention about what was meant by the law that he signed has any bearing on the interpretation? I mean, usually we're looking at legislative intent, and so the idea about the governor saying anything, I just wonder, well, what's the authority for that?
I don't know if there's express authority there, but I think it's indicative of the fact that at the very best for the other side, their language is ambiguous. And if you thought the legislature was really going to make this massive policy change, you would have thought they would have been a little clear about it, so at least the governor who was signing it would have known what he was signing and would have agreed with the legislature on this critically important issue. One of the points that Mr. Warner made, and this is a more minor point, is he distinguished between life-saving abortions and abortions in medical emergencies. And he said not all life-saving abortions are emergencies. I do want to note that's contrary to what the petitioners said in their petition for review on page 10, in which they conceded that a life-saving abortion is a medical emergency. As for the issue of currently, I agree with Mr. Gaona, it's not a verb, so 1214 doesn't apply. But 1214, to your question, Justice Pollack, is also a presumption. That's what ARS 1211 tells us. And the court applies that presumption unless the legislature is otherwise clear. There's not another form of currently to use. Currently means the present tense, right? And so if they're using the word currently, and as they said in that sentence, the legislature does not intend this act to make lawful an abortion that is currently unlawful, they're talking about their present intent. And so we don't need 1214 because the words are clear on their own. I'd also point the court to its decision a couple months ago in the Avitius case, in which the court looked at the tense of statutory words to figure out what duty those words imposed. And it didn't say, well, we rebut that based on 1214, because the court could tell that the tense of the words actually indicated the meaning of the statutes in question. In In terms of the right versus permission issue, I think it is very clear that a right is very different from a statutory permission. Rights have specific legal consequences that permissions don't necessarily have, so rights can vest. Rights can trigger other legal protections, like the protection of the Equal Protection Clause or the Due Process Clause. Rights can be actionable for money damages, but here the legislature was just permitting certain conduct, which is different from a right. And I don't think anyone on this side of the aisle is contending that the 15-week law creates a statutory right to an abortion, but that doesn't tell you anything about what the 15-week law permits.
It's very tough to find a case that is similar to this one in all of American jurisprudence. But the one that seems closest to me, or at least on its surface, is the Batchelder case from the U.S. Supreme Court in 1979. And there, Congress enacted two independent gun control statutes, each enforceable on its own terms. And the court, at the end of the day, said, you know what, we're going to enforce them both. It's a matter of prosecutorial discretion on how to enforce them. And there's no due process violation, to return to a point that the Vice Chief Justice was asking about. If the law is very clear in both instances, and I doubt that you are arguing that the law is unclear in either of these statutes, but in fact, I think they're rather measures of legislative clarity, at least insofar as the text is concerned. Why is that not the lodestar that we should follow?
It's a good question, Justice Bullock, and I'll confess I haven't read that case, at least recently, so I appreciate your summary of it. What is critically different here is that the 15-week law and many of the other statutes in Title 36 contain permissions and not just additional prohibitions. That's based on the plain text. And so you have a conflict that I think, based on your description, you didn't have in the Batchelder case. There you just had several prohibitions, right? We prohibit DUI in several ways. Right? It's different crime if your BAC is above a certain level. We can have overlapping prohibitions. The issue comes when we have a combination of permissions and prohibitions. Then we have statutory conflict. We need to do statutory harmonization. And given the basic canon that more specific and recent statutes govern to the extent of conflict over older, more general ones, I think the Court of Appeals got it right. I should yield the remainder of my time to my colleague from Pima County.
Mr. Brown, you have 3.5 minutes.
And can you break the tie between your colleagues?
I will attempt to be succinct. I'm here to speak directly to Vice Chair Timmer's point about due process. In Arizona, the law must be clear. Here, as we just mentioned, there are conflicts when we are attempting to criminalize in one law that which is permitted in another. The Court of Appeals interpretation here makes the law clear. Doctors can provide an abortion before 15 weeks or in a medical emergency.
I hate to ask this threshold question, but where is the rule that Arizona law must be clear?
That is a great point.
I think that's rhetorical.
I was actually hoping there was an answer to it.
We have searched. In Hayes, the court found that when interpreting statutes, we assume our legislature has enacted them to avoid unconstitutional results. Due process requires that laws make sense to ordinary people. What the intervener has argued to you is that due process problem is resolved at the back end when prosecutors are making decisions. We submit to you that process needs to be addressed at the front end. People need to be on notice of what's prohibited, what's illegal, and leaving it to the back end doesn't solve the constitutional problem.
But as Mr. Warner correctly points out, the physicians are on notice that you may not perform abortions at all under either statute, unless it's life-saving, that kind of thing. So you're on notice, the physicians are on notice. There seems to be confusion on, well, what the penalty will be for that. Does your argument of due process apply to the penalty phase as well, or are you saying that it's unclear what's prohibited under Mr. Warner's interpretation?
Your Honor, I'm arguing the latter, that under Mr. Warner's interpretation, even within the text, there are some issues. For instance, 3622 allows an abortion in a medical emergency. 3603 would criminalize that very same act. Another example, ectopic pregnancy is defined as not even an abortion in Title 36. That is an act that would be criminalized under 3603. And finally, the most obvious one, which is an abortion by a licensed physician complying with Title 36, is allowed under Title 36 and is criminal under 3603, given the intervener's interpretation. The intervener also suggests that nothing suggests prosecutors will make arbitrary enforcement decisions. We are here today from the Pima County Attorney's Office with a different interpretation than the Yavapai County Attorney's Office. The former governor has had a different interpretation of the statutory scheme than the former Attorney General. And as the amicus briefs make clear, legislators who debated and voted on this bill have different interpretations. There is maybe never been a case where there is a potential for arbitrary enforcement such as this, and we're asking you today to resolve that for the statutory construction problems and issues that have been discussed, but also bearing in mind the constitutional problem that doctors and the people of Arizona need to be clear on what is illegal and what is legal. That's all. We did it in 3.5 minutes. Thank you.
Thank you, Mr. Friend. Mr. Warner.
Thank you. Title 36 and Section 13-3603 fit together in a very straightforward way. Up to 15 weeks, the termination must be life-saving. After 15 weeks, the termination must not only be life-saving, but immediately necessary to protect the mother. Not all life-saving terminations are immediately necessary, and petitioners never weighed this argument. The text that the Attorney General quoted was from our petition, which said, for those life-saving terminations which constitute medical emergencies. We've exemplified this argument many times, including on intervener supplemental brief pages 13 and 14, and the Attorney General in briefing below mentioned it on pages 50 and 51. This application of law protects the mother while respecting the state's growing interest in protecting unborn children as they near viability. There's no conflict, and the limiting directives ensure this result. The legislature said Title 36 does not repeal Section 13-3603. It creates no right to an abortion and does not legalize any current...
So Mr. Barrett points out the question of an ectopic pregnancy, which appears to be legal under Title 36, but appears to be an abortion illegal under 13-3603. What do we do with that?
Those terminations are always considered life-saving and would not be punishable under either 13-3603 or the 15 weeks law. Physicians note that those are emergency situations, so both exceptions in both laws would qualify.
But if you're a physician and you read 36-3322 subpart B, it wouldn't tell you that you can perform abortions up to 15 weeks as long as it's to save the life of the woman.
Well, certainly we would hope that the physician would read the entire text that the legislature has enacted, which includes Section 13-3603.
So the physician would have to read the Title 13 and the Title 36 provision together and just know that to know what's prohibited.
Of course, Your Honor, and this applies that way in certainly many contexts where conduct is regulated through multiple statutes. In fact, that's what physicians have to do right now, looking throughout the totality of Title 36 when understanding the contours of when it's appropriate to conduct a termination.
But very few of them say it's okay to do it in this context, but criminalize it elsewhere. That's a little unusual.
I'm sorry, Your Honor, I don't think I understand that question.
Well, a physician who read 36-2322B would think that they could perform an elective abortion up to 15 weeks and would have to figure out elsewhere that it's criminalized in a different section of the statute. That's not the usual course of conduct.
Well, that provision only purports to regulate terminations after 15 weeks. It's our hope and expectation that physicians would look at the full code to understand what applies before 15 weeks, and that includes Section 13-3603. And that also triggers the construction directives. that Title 36 creates no right to an abortion and that it does not repeal Section 13-3603. And I want to be clear about that full line. Title 36 does not repeal Section 13-3603 or other abortion regulations. SB 1164 is the subject of that sentence, so it does not qualify as an other law in the predicate of that sentence. So I don't believe there's a conflict here, Your Honors. But if there is a conflict, the legislature has given it express direction. The pre-row law, Section 13-3603, is the winner if we have to choose between Section 13-3603 and Title 36, specifically SB 1164.
How do you respond to Mr. Gayona's point that the reference in the session law to or other laws regulating abortion refers to what he called the reason law, could also refer to the judicial bypass law as well, that you still would need to get permission of the minor or minor's parents or court before 15 weeks. So why couldn't that language refer naturally to those types of statutes?
Yeah, Title 36 can regulate more conduct than Section 13-3603, but a repeal occurs when a formal law can no longer regulate the conduct that it once did. And as I mentioned earlier, those other laws certainly fully apply after the injunction below is lifted because they can apply in non-emergency situations. Because not all life-saving terminations are emergencies, those laws will have full vitality after the injunction.
Judicial bypass would never have full vitality because that's exclusively for elective abortions, aren't they?
I don't believe it's limited to that, Your Honor, under the text, because even in life-saving terminations, the legislature has required informed consent when the exigency allows, and this presumes that the life-saving termination is not an emergency and can trigger that law. In conclusion, I want to say that the text here fits the context. For over 100 years, Arizona has fully protected life from the moment of conception. Roe temporarily stopped that protection, but the legislature never gave up, reaffirming its commitment to Section 13-3603. We ask this court to reverse and fully remove the injunction below. Thank you.
Counsel, thank you for the arguments today and the supplemental briefing. This matter, the case is now at issue. An opinion will issue in due course, and the court will take a brief recess pending the next case.
Hello, everyone. Thank you for being here. My name is Bernadette Tacey with Alliance Defending Freedom, and we are the world's largest legal ministry dedicated to protecting the sanctity of human life for religious freedom, free speech, parental rights, and marriage and family. Today you'll be hearing from Jake Warner, Senior Counsel with Alliance Defending Freedom, as well as Dr. Hazelrig, Dr. Eric Hazelrig, who is the Medical Director for Choices Pregnancy Centers. And we'll start with Jake first.
Last year, the U.S. Supreme Court allowed states to fully protect life again. This is welcome news for Arizonans, who have a long history of protecting life. We codified our pre-Roe law over 100 years ago, reenacted it in 1977, and reaffirmed it just last year. All life is precious and valuable the moment it comes into existence. Life begins at conception. At just 6 weeks, an unborn baby's heart begins to beat. At 8 weeks, she has fingers and toes. And at 10 weeks, her unique fingerprints begin to form. Many states, like Arizona, are recognizing the humanity of unborn children and giving them a chance at life. But the abortion industry continues to push an extreme ideology on Arizonans and Americans across the country. Abortion businesses have a financial interest in performing elective abortions, not in providing information and options vital to the health of a woman and her child. They are doing everything they can to stop Arizona's life-affirming efforts. While abortion businesses, federal officials, and other states are pushing for policies that force taxpayers to fund elective abortions, remove conscience protections for healthcare professionals, allow abortions through all 9 months of pregnancy, and allow minors to obtain abortions without parental consent, Arizona's law affirms that life is a human right. I'm hopeful that the court will uphold this life-saving principle.
Hello, my name is Dr. Eric Hazelrig, and I'm honored to serve as a representative for unborn children in Arizona in this important case before the Arizona Supreme Court. I'm committed to respecting human life at every stage, and as an OBGYN, it is a privilege to help families meet their newest members. Arizona's pro-life law affirms the dignity of every man, woman, and child across the state. Over the last almost 35 years, I have been blessed with the opportunity to deliver over 15,000 babies, each one of them unique from the moment of conception. And I have the honor of serving the women and families bringing those children into this world. Each woman I serve is also unique. Both deserve real support and real health care. I also serve as a medical director for Choices Pregnancy Centers. At Choices, we don't perform or refer for abortions, but instead provide a safe place to talk, explore options, seek medical services, receive resources, and hear about the hope available to all of us for a better life. That's real care. Dozens of other pregnancy centers across the state are ready to support women, providing free material resources like diapers, baby clothes, cribs, and car seats, as well as parenting classes and other programs. We pray that unborn children will be protected under Arizona law and that women and families receive real support and real health care. We all deserve the dignity and respect that is upheld by laws that affirm that life is a human right.
Are you taking questions?
Yes, they are taking questions.
Okay. Let me ask an obvious political question. We heard the attorneys, and I know every attorney comes out and says what a brilliant job they did. Assuming you win, doesn't that put more pressure on voters to say if the alternative is zero abortion or the ballot measure, doesn't that essentially put pressure on folks to say, given that choice, I will approve the measure in 2024? Whichever one you wants to handle that one.
Arizona has every right to fully protect unborn life, and for over 100 years, Arizona has affirmed that life is a human right. In 1977, Arizona reenacted its pre-Roe law, fully protecting unborn life from the moment of conception. Just last year, the Arizona legislature, the voice of the Arizona people, reaffirmed the original pro-life law. That tells us that the Arizona people want to affirm that life is a human right. Whatever may happen in a future legislature or through the ballot initiative, life should be protected. Life begins at the moment of conception, and Arizonans have every right to protect unborn life.
So basically you're saying that because the legislature in whenever, approved Roe v. Wade, approved the 15-week law in 2022, we know what the governor said about that. You're saying it will have no effect on voters in November 2024?
We're not here to discuss politics in court today. Arizonans have a right to protect human life from the moment of conception. And the legislature has repeatedly affirmed their commitment to protecting the unborn in Arizona. That is reasonable and right. It's a good thing to do. And we're very hopeful that Arizona voters here and in the future affirm that life is a human right for everyone.
So one of the pillars of your argument before was the difference between abortion between saving the life of the mother and something that's immediately needed when we think it goes to 15 weeks. What's the difference? What's an example of something that's an emergency, or something that's needed to save the life of the mother, but not an emergency? We have post-15-week emergencies.
Dr. Hazelrig might be best available to answer that one.
I think an example you mentioned in court was maybe a cancer. A pregnant woman has a breast cancer or has a cervical cancer that was diagnosed at one of her prenatal visits. That would be a life-threatening condition, but would not necessarily immediately threaten the mother's life or the baby's life. Whereas if a mother, let's say, was in heart failure and a delivery or pursuing the rest of the pregnancy would put her life at immediate risk of dying, then that would be an immediacy.
But if a doctor knows at 6 months of pregnancy that a woman will die if she gives birth, that would not be immediate, but would they have to wait until the woman's actually giving birth to perform the abortion at that point?
That would, if she's going to die giving birth, that would be more of an immediate concern as opposed to something that potentially could kill her.
And I'll note that
that wouldn't be immediately necessary at 6 months?
Well, let me say this. At 6 months, there would be another law here that would kick in, Arizona's viability law. Our legislatures has said that unborn children should be protected to the fullest extent possible. So at 6 months, it's very possible that we're talking about a viable unborn child. And physicians are required to do everything necessary to protect those children because life is a human right. And we here in Arizona, we support that right.
How do you square the conflict that we heard about today? If both laws are in effect, they believe they can coexist, correct?
Oh, absolutely.
So what is a doctor to do when a woman comes to him at, say, 4 weeks and seeks an abortion? And under one law, that's legal. Under another law, that's banned.
Well, under one law, it's not regulated. It's regulated under the pre-Roe law. So when the doctor receives a woman in that condition, he just needs to make a good faith judgment about whether the termination is life-saving or not. If the termination is life-saving, then that termination is not punishable under Arizona law.
So you're saying the 15-week ban really isn't in effect, but under the 15-week ban, the doctor can go ahead with that abortion. It's legal for 15 weeks, correct?
Well, you have to look at the law in its entirety. We don't just hand-pick certain statutes to follow and others to not. The pre-Roe law fits together with the 15 weeks law.
So
What about the Cape Cod situation in Texas? How is that applied here? The Cape Cod situation in Texas.
There you're talking about different laws and different facts. Here we're dealing with a facial challenge, which means that we're dealing with how these laws logically fit together like a puzzle. And Arizona has fully expressed its commitment to protecting unborn life from the moment of conception. And we're very
about the circumstance. We're looking at a similar situation here, where even the judge says, she needs it. But multiple doctors said she needed it. It's threatening her health.
And to be clear, I don't know the entire facts of that case, but here in Arizona, if the termination is life-saving, it's fully allowed under Arizona law. And after 15 weeks, if it's life-saving and immediately necessary to either protect the woman's life or to prevent significant and irreversible bodily impairment, then that termination is allowed. That's how these laws fit together.
But are you worried that so you're saying that the two laws do not?
Absolutely not.
So those laws don't conflict each other. Are you worried that medical providers are going to be confused about the language of those laws? And how would you like to see that be seem like it might be inappropriate.
Yeah. Well, the legislature has made its intent clear by the text that it has enacted. They have affirmed that life is a human right, so we would expect physicians to look not only at the 15 weeks law, but the pre-Roe law to see how these requirements fit together, and certainly clarity will hopefully come from the court, which is why we're here today. We want the Arizona Supreme Court to affirm that life is a human right and uphold the legislative intent to keep its pre-Roe law, protecting unborn life from the moment of conception.
If both the life-saving choice and the immediate life-saving choice are different, then why would we not want to save the life of the mother, whether it's immediate or not immediate?
Well, it's because of the growing interest of the state in protecting the unborn child. The viability line for unborn children has been going down and down for the past 50 years. So at 15 weeks, the state comes in and says, hey, at this level, we need to balance protecting the mother's interest as well as the unborn child. Arizona is trying to protect as much life as possible here, and it's found a reasonable solution.
So why wouldn't the legislature just spell this out more clearly? And if they didn't have the votes to do so, could that really be their intent?
Well, it's very clear. We can certainly debate the grammar of how the legislature conducted its law, but the text is very clear in what the legislature accomplished.
Well, if it were that clear, I don't think probably any of us would be even talking about this. I mean, other states like Mississippi, states where they've had trigger laws on the books did make it very explicitly clear.
But Arizona used its own text. There's nothing that requires Arizona to match Mississippi's text. We have used similar language over the past 50 years in nearly 10 different laws. So we just use the same text we've always used.
But why would they leave it open to interpretation if they had the votes to make it clear?
Again, that's the dispute of the case, and we believe the text is very clear in that it affirms that life is a human right and that nothing in the new laws repeal the pre-Roe law that fully protects human life.
One of the last things the Chief Justice said to you was that it would be unusual to expect a physician to read through all of these to figure out when it's... Are you concerned about that word, unusual?
I don't think it's unusual at all. In fact, that's what physicians have to do right now. Title 36 is a catalog of different statutes, and physicians have to piece them all together to know what is required and what is not required. This is just saying, look, we have to look at all the laws, including the pre-Roe law.
Are you concerned the Chief Justice thought it was unusual?
Now, I'm confident that the court understands that Arizona has been fully committed to protecting unborn life, and they've made every effort to do that over the past 50 years.
Arizona history shows that abortion wasn't stopped because of the pre-Roe law. There were abortions going on, they just weren't as safe. Is that kind of what you'd like to see that return to?
All human life is worthy of protection, so Arizona is well within its reason to affirm that life is a human right from the moment of conception, and we support Arizona's law here.
Time for one more question.
Just to follow up on Ray's question, all life is worth protecting. Are you worried that if the court sees things roll away, that the court will go back alley by market abortions that are significantly less safe for women involved?
Well, the answer is not to add injustice upon injustice. The Arizona legislature is very reasonable in wanting to protect as much life as possible. All human life has dignity. We're here to affirm that life is a human right. It begins at conception, and science over the past 50 years is increasingly proving that this is the right answer. We're very hopeful today that the Arizona Supreme Court will affirm that life is a human right for all, including some of the most vulnerable among us, unborn children. And we're very confident that the court will see the...
Abortions occurred in Arizona prior to Roe. They just didn't occur legally, which gets to his point. Abortions will not stop. So are you essentially forcing folks out of the medical system? Is it away from qualified doctors?
There's no reason for the state to support that activity. The state regulates all kinds of conduct, and they always want to ensure and protect life to the greatest extent it can. Whether that happens in fact, we certainly hope it does. But the state is well within its reason to affirm that life is a human right.
All right, thank you everybody. If you have any other questions, please come and talk with me. If you need a name spelling or if you need anything else, please come and see me afterwards. Thank you so much.
Thank you. Good job, guys.
Thank you. The Attorney General is going to make her way out here now.
So we want somebody more interested.
How are you? Hi, how are you? Yes.
Hey, Ashley.
Do you all mind moving?
All right, moving.
Thank you. Hard work.
All right, we ready?
We're ready.
Stacy, I was like, what are you talking about? Okay, let's get started. Hi, everyone. I'm Chris Mays, the Attorney General of Arizona. Thank you for being here with us today. This specific case is about the need to harmonize Arizona statutes to ensure that women aren't saddled with an 1864 law that was passed before Arizona was a state, before women had the right to vote, and while the Civil War was still raging. But I think we all know that this is about something much bigger than that. We want to be certain that what transpired in Texas over the last several days never happens in Arizona. What has happened in Texas is nothing short of egregious, disgusting, and heartbreaking for Kate Cox, her family, and her doctor. Their Attorney General petitioned the Texas Supreme Court to freeze her permission to obtain an abortion that her doctor said was needed to protect her life and her future fertility. That Attorney General threatened any doctor or person who helps her with punishment that includes a life sentence in prison. This should be absolutely chilling for all of us, and it should serve as a very important reminder and warning about what can transpire when the government gains control over what should be very private decisions between a woman and her family and her medical providers. It should serve as a stark reminder of how important this case is to the women and to the people of the great state of Arizona. With regard today, I am extremely proud of my team's dedication and hard work on this case. I want to personally thank my Solicitor General, Josh Bender, as well as Lucy Davis, Alex Samuels, and Haley Crawford, who heads up our reproductive rights unit, the first unit of its kind in Arizona that I implemented upon taking office. The real-world consequences of this case are huge. Whether abortions will remain legal up to 15 weeks or whether abortions will only be allowed when it's necessary to save the life of the mother. And we have all seen how that has worked out in other states across the country with abortion bans. I believe that the Arizona Court of Appeals got it right last year when they ruled that the modern statute superseded the territorial ban. And I'm very hopeful, especially based on what we heard today, that our Supreme Court agrees with that ruling. I know that the justices are going to thoroughly consider the arguments that were made today. Arizonans deserve certainty when it comes to our reproductive health, including the right to have an abortion. Our medical professionals deserve certainty too. And as your Attorney General, I won't ever stop fighting for our bodily autonomy and control over our own destinies. You have my word on that. And with that, I'd like to turn it over now to Pima County Attorney Laura Conover to say a few words, and then we'd be happy to take questions after. Laura.
Thank you. Good morning. I want to start by thanking my team as well. Sam Brown had the final word this morning. He's the Civil Chief Deputy at the Pima County Attorney's Office, and he's been here every step of the way. The chronology of this case was a protection. existing in Pima County Superior Court going back to 1973. We were there at the trial court level. We advanced quickly to an emergency request to the Court of Appeals, and we won at the Court of Appeals, granting statewide protection that still exists today. The difference now at the Supreme Court, obviously, is that I stand beside Attorney General Chris Mays instead of against and fighting against the Attorney General of the previous administration. And I want to make it clear that as Southern Arizona's top prosecutor, public safety and public health requires certainty and notice. We cannot have confusion in the laws. When we lost at the trial court level last year, due to our police chief in Tucson, our sheriff in Pima County, and my repeated statements about focusing on violent crime with limited resources, reproductive health care continued in Southern Arizona, but little elsewhere in the rest of the state. That's an equal protection and an equal access problem that should alarm all of us. We are very hopeful that at the end of today, the court will take under advisement all of the stellar arguments that were made today and rule in our favor.
Okay,
So,
any questions?
Let me ask the same question I asked the other side from a different perspective. I've seen polling on this issue. There's likely to be a measure on the ballot in November. If, in fact, you go back to Roe, I think that adds pressure to enact that. If, in fact, however, you win and the court decides 15 weeks is fine, which is more than 90% of abortions occur within 15 weeks, doesn't that reduce the need for voters to go ahead and enshrine constitutional protection into the Constitution?
I don't think that it necessarily does, Howard, because as you know, the ballot initiative would go beyond 15 weeks, and so I'm not here necessarily to talk about the ballot initiative, but it's going to be important for the people of Arizona ultimately to have the final say of this issue, and I'm hopeful that that initiative will pass. It will, it will end this debate, but between now and then, what this court decides will be incredibly important. Right now, though, as you know, I am not a huge fan of the 15-week ban. Let's remember the 15-week ban, in addition to the territorial ban, has no exception for rape or incest. But at least it's some certainty for abortion providers up to 15 weeks. So I think we do still need that initiative, and that'll be important. But this case was fundamentally about statutory interpretation, and it was about trying to prevent the reimposition of a territorial abortion ban on the women of Arizona.
If the Supreme Court does return to the territorial law, will you enforce that?
Well, I've been very clear that we are not going to prioritize prosecuting doctors for abortion in the state of Arizona. So, no, we will not be doing abortion prosecutions in Arizona while I'm Attorney General, ever. We have much more important issues to decide and work on in this state. I'm busy prosecuting the drug cartels who are killing our kids with fentanyl. I'm busy protecting our consumers. I am busy protecting our environment and fighting for our water supplies. I do not think it is a good use of the resources of the Attorney General's office to prosecute doctors.
Obviously, the language in the 15-week ban about not repealing 3603 could have been clearer, as we heard today. But how can it be argued that the legislature really intended for anything but that law to be enforced, if possible, to enforce it? I mean, if it wanted to draw a kind of a more technical distinction between like doctors and non-doctors and other people performing abortions, wouldn't they have laid that out more clearly?
Well, I actually think several of the justices made really good points, and they were points that were made by our team by Planned Parenthood, that if the legislature had wanted the territorial ban to go into place, they would have passed a trigger provision in the law, and they did not do that. And if the legislature wanted us to go back to 1864, they could have made that clear. What they did was they passed a 15-week ban and said that up to 15 weeks, abortions are allowable, and that for the life of the mother, abortions are allowable after that. But so I think it's very obvious that the legislature didn't pass a total ban. They were intending to mimic the Mississippi provision, and they could have gone all the way to 1864 if they had wanted to at the time. And I think, as our attorneys said during the oral arguments, even Governor Ducey believed that the 15-week ban would be in place. And I think that's very persuasive, circumstantial evidence that that's what was intended.
If they had intended, if their intent was as your side laid out in court, wouldn't they have said that explicitly in the law as well?
No, I think they passed the law that they meant to be in place. I mean, it's very simple, and they passed a 15-week law. I mean, there was, as you guys know, having been around in the waning hours of the legislative session, there was a push to try by Jay Kaufman and others to try to get a total ban on abortion into place, and Ben Toma pushed back against that, and they didn't do it. They passed a 15-week ban, and so I think that's what holds now, and I think that's the fundamental argument that we made. And then I don't want it to be lost as well what this case really was about, which is that when you have a more general and an older law, and then you have a newer, more specific law, basic and well-accepted statutory interpretation says that the newer, more specific law holds.
So are you concerned about enforcement at the county level, that county attorneys, if the ruling does go with the territorial ban?
Laura, do you want to handle that?
Well, that's absolutely the concern, and it goes back to equal access. You're going to have 15 county attorneys interpreting the law and using the resources that they have, which is always limited, and discretion will take place. I continue to think that the uncertainty and the confusion is not going to be with enforcement. It's right now with the law, and the law needs to be clarified. One thing I'll also say as well that I think we all heard in there were a lot of brilliant legal minds who have studied the issue. But to my knowledge, no one behind the bench or in front of the bench has a medical degree. And that's the problem with all of this. This is a public health issue, and it's a conversation between a provider and a patient that sometimes occur while the patient's life is absolutely in danger right in the emergency room. And so I think the people of Arizona are going to have the final word ultimately and decide that this shouldn't be determined by the government, that the government shouldn't intervene in between a patient and doctor, that this is a health issue and the government should step out of it.
I have a quick question, I'm sorry, Attorney General, of appearances here. So we've heard multiple times from the podium today and from this side of the argument that this is an issue that is between a woman and her doctor. And this case today is entirely argued by men. Can someone please comment on that?
Well, first of all, I'm the Attorney General, and I am a woman. And I certainly participated and directed the preparation of this case. It was also, we had, as I mentioned from the beginning, we had several female attorneys working closely on it. I'll be honest with you, we had this discussion. When we were preparing the case, but ultimately we assigned the attorneys who had been working on it the longest, and Josh Bender is the best lawyer in Arizona. So I'm the quarterback I'm the coach of the team. I sent in the best oral arguer in the state of Arizona, a guy with tremendous experience. But we had women working on this case, and I'm the female Attorney General of Arizona, only the second female Attorney General ever to serve.
Can I add a word? I'm sorry.
Oh, and Laura's
I
a woman, too.
really like to add a word to that, because I appreciate the question, I do. And I am the Pima County Attorney. And what I'll add to this, and what we have seen time and again, when we are talking about the life of a woman being at risk in an emergency situation, all too often, it's the husband pacing in the room, it's the partner pacing in the room. This is, the ripple effects affect families. And the stories that we have heard nationwide about couples being sent back out into the parking lot to wait until your life is in danger enough, then come back in, and then we can provide you life-saving care. This affects whole families, including older siblings who are sometimes waiting for mom and dad to come home with the baby. These are the life and death situations at play and the real world consequences when we inject the government and the legislature and the courts and prosecutors and law enforcement into a healthcare decision.
Let me follow up to the question that he asked about county attorneys.
Yeah, I was just
Laura
going to
answered,
come back to
which
that.
is the issue of the governor contends she issued an executive order saying she's turning it all over to you. These county attorneys are elected. Do you honestly believe that you can stop 15 county attorneys, or maybe 14, taking out Laura, from enforcing the law if this case, according to Site 133603, prevails?
So, yeah, I mean, I believe that the governor's executive order should be enforced. I believe that she placed the decision-making authority over abortion prosecution in our office. And if any county attorney attempts to prosecute a doctor or a medical provider for abortion, I will exercise my supervisory authority over that county attorney, and I will seek to stop it. I would have done that without the executive order. I mean, let me be clear, I have supervisory authority. I made it clear on the campaign trail that I was going to exercise supervisory authority over any county attorney who attempted to prosecute women or doctors. And I do think this is an important question. We have one county attorney, unfortunately from my home county, Yavapai County, who was an intervener in this case, who, you know, you have to wonder what his intentions are. What does Dennis McGrain intend to do in Yavapai County? If I'm a medical provider at the Yavapai Regional Medical Center or the Cottonwood Hospital, I got to be worried about that. And so that's one of the reasons this case was so incredibly important. And so, yeah, I do intend to enforce that executive order. We've had some good conversations with county attorneys, and I understand where they're coming from on this issue and whether it sets precedent for other matters. We've had some really good conversations, but I've been really clear that I don't want to see them moving forward with prosecutions, and if they try, I will stand against them.
The law the governor cited in her executive order has never been litigated, and it's only been used once. How confident are you that will stand up in a court challenge, which will almost certainly no? Yeah, well, we'll see. I mean, well, let me put it this way. I hope we won't see, because I hope what the county attorneys will do, and I believe that there aren't very many county attorneys chomping at the bit to prosecute doctors for medical care. But we do have one county attorney, Dennis McGrain, that apparently believes in the territorial abortion ban. And we have the Maricopa County Attorney, Rachel Mitchell, who has been clear as mud about exactly where she stands on all this. Yeah.
Given what you've heard from the mostly conservative judges, just how confident are you that the outcome is going to be has been elevated since you've talked to them, or since you've heard it today?
Yeah, I thought the questions from the bench were excellent, and they were clearly fully engaged. They were well briefed. They had read all the pleadings. So you never want to predict what a court is going to do. I'm sure Josh would get really upset with me if I tried to do that. But I thought their questions were excellent. I feel very good about the direction that their questions, at least a majority of the justices were going, and we'll have to see. I can't fathom a situation in which our Supreme Court wants to take us back to 1864, but we will see, and we'll deal with that when it's over with.
We got time for one more question. One more. If anyone has one.
We're waiting for the re-election announcement.
What, Howard? No, okay. All right. Thank you, everybody. We appreciate you. Thank you. Thank you.
Get it on the ballot. Voters decide. Get it on the ballot.
Barb, I think Planned Parenthood's
Who's
Oh, yeah, sorry about that. I had a sitting on the fence, but I had to hang on there. Well, okay.
Whose is this? Who's wireless? Oh, yours? I'm taking
Oh, you're
this
taking this?
podium. Yeah.
Okay.
Sorry.
You're good. Sorry.
Whose is this? I'm taking this podium, so.
Oh, you get the wireless mic then.
Yeah, I don't want it.
I'll take the mic stand, guys. I gotta go, so sorry.
Here, I think
Yeah.
We have another mic stand
Yeah.
for PPAZ statements coming. If anybody wants to stay for that.
Guys, I'm gonna take the mic stand. I gotta run, sorry. Yeah, sorry, you guys.
Here.
AZ family?
Thank you for taking that question.
Oh,
I'm Stacy Bartner with the Arizona Republican.
I got that. We're gonna try to grab it.
My name's Molly Gutterud. I'm at Planned Parenthood, Arizona. Today you will hear from our Chief Medical Officer, Dr. Jill Gibson, followed by our legal counsel, Andy Granoa, and then we will take questions after those statements. And without further ado, please, Dr. Gibson.
Thank you, Molly. Good morning, and thank you to everyone for being here today and covering these important events. My name is Dr. Jill Gibson, and I am the Chief Medical Officer at Planned Parenthood, Arizona. As an obstetrician gynecologist who has treated hundreds of patients seeking abortion care for the past 14 years, and a mother of 3 little girls, I know firsthand that comprehensive reproductive care and access to abortion for all people is absolutely essential. Criminalizing abortion does not reduce the need and demand for this basic healthcare procedure. If the court allows this archaic, near total abortion ban to go into effect, there would be an immediate and devastating real-life effect. Our patients will be forced to seek abortion in other states, away from their support in their communities. They will struggle to find someone to watch their children so that they can travel, to get time off of work from the 2 to 3 jobs they hold down just to make ends meet. But the truth is that the vast majority won't have the resources to make it out of state and will be forced to carry pregnancies and raise children that they recognize they cannot emotionally, physically, or financially support. Let me tell you about a patient that I cared for recently. This patient is a mother. She works. She is doing what she can for her family. But she has a partner who physically abuses her. She said to me very clearly that, quote, "I know that if I don't have an abortion, the physical beatings will only get worse for me and this child. But at the same time, my partner would never allow me to have an abortion." So she plans for an abortion by pills, so it might appear as though she miscarried, and reduce the chance that her partner finds out the truth and abuses her more. How would this patient, whose actions and activities are heavily monitored by a violently abusive partner, get out of state for her abortion? An abortion ban effectively tethers her, and so many others in similar positions, to toxic and harmful partners. Abortion bans not only negatively impact individual lives, they impact families and generations, and perpetuate other systems of oppression. Let's consider for a moment another systemic problem that will be amplified if an abortion ban takes effect. Arizona's maternal mortality rate has tragically quadrupled over the past 2 decades. Quadrupled. Data from the year and a half since the overturn of Roe v. Wade show that pregnant people in states with abortion bans are nearly 3 times as likely to die in pregnancy, childbirth, or soon after delivery. Are we prepared in Arizona to intentionally cause our maternal mortality rate to become even more unacceptable? We know that abortion bans have the greatest impact on Black, Indigenous, Latinx, LGBTQ+ folks, and undocumented people, all those groups who already face systemic discrimination in our healthcare system. A near total ban would be devastating for these communities, furthering legacies of harm. Arizonans deserve better. The court has the opportunity to refuse this bleak future, and I am here today with the hope that the court will side with the majority of Arizonans in rejecting this extreme, unpopular, and egregious threat to reproductive health care. I hold on to the hope that I and my fellow health center staff will be able to continue to provide the life-saving and life-changing care that our patients so desperately need. And while I know that you all have many questions today, I do want to make one last point very clear. Planned Parenthood Arizona's doors remain open, and we are committed to providing sexual and reproductive health care for all Arizonans, including abortion. We know that the work is far from done, and Planned Parenthood will not stop fighting for our patients at the courthouse and beyond. We won't stop. We won't quit. We will restore a state that respects bodily autonomy. Thank you. And I'll turn it over to our legal counsel.
Yeah, there's a lot of...
Yeah. We purposely arranged that. Thanks, Howard. I appreciate that. What's up?
Well, good morning, everybody. I'm a lawyer, so I do most of my talking in court, whether it's standing up there as I was earlier or in writing. But what I will say that I feel confident after today's argument that the court will put precedent over politics and rule in favor of Planned Parenthood and to ensure that Arizonans have access to abortion up to 15 weeks LMP. In our view, this case has been clear and straightforward from the get-go. There have been some hiccups along the way, including leading Planned Parenthood to have to close its doors to patients for a while. That was a tragedy. It can't happen again. It shouldn't happen again. And I have every confidence that the court will see through the interveners' arguments that are based not truly in law, but on their fundamental opposition to bodily autonomy for pregnant people, and uphold the 15-week law passed by the legislature in 2022. The real heroes in all of this are Dr. Gibson and the clinical staff at Planned Parenthood and the other providers in Arizona. They're the ones you should want to talk to about their experiences under these laws and these restrictions. And we should all be thanking them for providing such an important healthcare service to pregnant Arizonans amidst a very volatile climate, amidst protests, and that is why this case is so important. Doctors need to be able to provide health care to their patients. The state shouldn't get in the way of that, and we sincerely hope that the Supreme Court agrees with that. So with that, Dr. Gibson and I are happy to take questions.
Jill, let me ask you the same question I've asked everybody else. We have an election coming up, presumably in November. I've seen polling in terms of where people stand from 0 weeks to 22 or out to 39. Most abortions, as you know, in this state are performed before 15 weeks. If you win, doesn't that reduce the pressure on folks to say, we don't want anything that theoretically allows post-viability abortions in certain circumstances?
So in a post-Hobbs world, we now have a very clear understanding that we need to do absolutely everything we can to ensure that we have protection for all aspects of sexual and reproductive health care, and we need that protection at the highest level. And that means that we will not stand for any bans. We know that bans simply make abortion out of reach for those who need it the most, and Planned Parenthood will continue to fight and advocate for those decisions to be made between a patient and their healthcare provider, and not the court of law.
Gibson, we heard a lot from the Alliance for Freedom attorney about the distinction between an abortion needed to save the life of the mother and one that would be life-saving but not necessarily an emergency that they believe would be permitted after 15 weeks. Do you view, in your view, what's something that would meet those criteria of an emergency but not immediately necessary?
That was a very confusing argument for me, and I'm not sure that has any standing for a physician. What I can tell you is that being a physician with those kind of stipulations puts us in a completely untenable position. A physician should not have to consult their attorney in order to understand if they can provide basic essential health care. And stipulations such as that the ADF attorney was arguing simply put doctors in really difficult positions and are going completely contrary to the oath that we have taken to provide the care that we know how to provide to our patients.
What, if any, contingency plans does Planned Parenthood have if the court decides to go with a territorial ban?
So Planned Parenthood offers a whole host of sexual and reproductive health care services. We are extremely proud of our abortion service line, but we actually have the majority of our services are preventative health care services. So patients come to us for their gender-affirming hormone therapy, for their STI testing and treatment, for their birth control. And we understand that if there is a complete abortion ban in this state, all of those services have a newfound importance, and we will be here to support our communities in that regard. We've also established a patient navigator program. Keisha Talbert is our patient navigator and registered nurse. She currently, even in the context of a 15-week ban, works every day helping to get patients who are in our state who need abortion care after 50 weeks out of the state. And so her work would become even more important with a total abortion ban so that we can help Arizonans get the care that they need. That would still be a commitment and a very important part of our work if this unfortunate ban were to take place.
Yeah, I think you're speaking to a really important point, and this is what we found since basically the leak of the draft opinion of the Supreme Court of the United States is that part of the most difficult part of what happened was that patients were really caught in the crosshairs of this argument that should really be left up to them and their providers. And so Planned Parenthood has worked really hard to have that education campaign, to be on social media disputing all of the misconceptions and all of the misinformation that is being spread very, very rapidly. But I have to say that a lot of our patients are already disenfranchised from the medical community. They already have reservations about coming in and getting care because there are just legacies of historic racism that take place in our medical system. And so we're already fighting that unfortunate reality, and now to have this additional confusion for patients and have to spend time talking to patients about what is legal rather than talking to them about their very real healthcare needs is a waste of time.
I wonder, would either of you like to address the question I asked the Attorney General, which is we hear a lot of this argument that from this side of the issue that abortion should be a decision between a woman and her doctor, but we have men entirely arguing the case in court. Would either of you like to comment on that?
So what I would say that I'm the Chief Medical Officer at Planned Parenthood Arizona, and I'm here today flanked by the rest of our representatives, April Donovan, our CEO, Chris Love, our Senior Advisor, Sheena Chang, our Board Chair. And what I think is really the most important part of this whole discussion is that we are here today because this is the team that feels the most passionately and speaks the most eloquently, and this is the team that we assembled because we know what's at stake and we know the importance of making sure that the Supreme Court hears our arguments and understands the realities of what this abortion ban could enact.
Are you an honorary girl?
You'd have to ask my daughters that, Howie. I don't know.
Thank you, guys.
Great. Thank you, everybody.
Thank you.